Check, 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 check. This is 6. Check, 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 check. Mic 6. This is a hearing assist check. 1, 2, test 1, 2, check, 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 check. Check. Oh, check, check. Check, check, check. Check, 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 check. Check. She wants it. They asked if they could have an audio recording and a WAV file.
Oh, yeah.
That's got a multi.
What's that?
Oh, do I have this on?
Tap on that real quick.
Check, 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 check.
So you need out to that.
Yep, it's a multi-jack, so it can be quarter-inch or XLR.
Actually, the aux outs are all quarter-inch.
That's what I thought. But this has, I don't have a.
I'll grab a quarter-inch.
I gotta remember to cancel our meeting. Check, 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 check. Hearing assist, check. That one's good. Check, 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 check. Hearing assist, check.
Hey Danielle, I just turned on the onboard mic. Can you hear that, Danielle? Question mark. Hey, testing 1, 2, 3. Danielle, testing 1, 2, 3. How's it going? Typing something to me. Hold on 1 second, Sam. Hush, get over the crowd. Oops. Okay, well, how about that, Danielle? A little bit better. This is probably more the levels I'll be using. How about this? This is probably where I'm going to use it or leave it at, Danielle. Does that sound good? It's going to be different quality and a different mic, obviously. I'm like 2 feet away from it. Okay. All right. So I'll sign off. Question. Question. Okay. All right. Great.
It should be fine. Yep. You're welcome. Check, 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 check. Check. Check, 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 check. Check into the audio recording, looking for that -12 to -6. Check 1, 2. Hot test 1, 2. Check, 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 check. Wasn't going down. Check, 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 check. Check 1, 2. Test 1, 2. That should be good. Check, 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 check. Headphone check in the recorder. Check, check, 1, 2. Check, 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 check. Check, 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 check. Check, 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 check. It's weird how that doesn't affect it. Check, 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 check. Oh, it does. Okay. Check, 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 check. Check, 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 check. Yep. Okay. I can control it here. Check, 1, 2, check, 1, 2, check, check, check.
Oh, it's really. Is it still going to pick me up when I'm standing? Do you think?
Yeah, I think it'll be okay.
Don't you think it should be
You can
higher?
get closer to it if you need.
Okay. All right. Man, I'm so profoundly uncomfortable.
Oh no.
Do you not like change? Do you not like
Change is bad always.
Change is bad. Do you not like change? People talk like it's great, you know?
No. No. All right, I'm gonna go before we start. I'm gonna use the bathroom, so I don't
Okay.
have to go in between here.
Yeah.
Middlebury guest.
Protecting the justices.
Yeah,
Snapchat.
here I am.
Oh no, possibly suspicious character. Click.
Yeah, here I am. Well, hey, the fire department guys do it all the time, right?
Do they? Has that been in the news?
Look
Can't
at
stop
'em.
reading the news.
Look at the fire department guys. They're always taking pictures of them in front of a burning building and stuff.
Really?
Oh, yes.
That's weird.
I'm like, if I go to a crime scene, I'm not taking a picture of me standing over a dead body going, yeah.
Yeah.
Right?
That's bizarre. I've gotten less and less interested in pictures. I hardly ever take any of my daughter anymore either.
I'll let the justices know probably about 5 minutes. Yeah, I'm just on Middlebury guest. I'm on Middlebury guest.
I'm just gonna make sure with them that they're ready. I think we do at like 9:30. We're ready. No water duties. They
What was
have
that?
a pitcher each.
I know. They should be good.
Okay.
They even give them napkins. 'Cause they
Great.
spill. Yeah. No, we filled their glasses, to make it more normal
Yeah, for sure.
to start out that way.
Sure. I do appreciate the goblets that they get.
I know.
Really? Although I said that and then Elder wondered, yeah, but they're not monograms, so.
So what's up with
It's-
that?
it's a
Come
town
on,
craze.
people. Yeah.
What's our time? I know Appali has 5 minutes. What's appellant?
Same.
Okay, great.
Yeah. I should have
let
remembered to
know
tell you that.
that.
Okay. It's going to be 5 minutes for the appellant. I don't know the appellee yet.
Before it's ready, I'm gonna get Sue to do the announcements if you guys are good with that. Yeah, let me
Awesome.
just let know about the times and then the times that they're all using. Oh, good idea.
Oh, my gavel.
Ooh, need that.
Man. This is going to be
You
an
probably have
all-time
to bang
high.
it hard in this room.
Yeah, of mistakes.
Okay, sounds good.
Oh, sure. Oh, great. Thank you. It's not on.
Good morning. Yep.
Perfect.
Good morning, everyone. Nice to see you all here. My name is Sue Ritter, and I'm the Special Assistant to the President and Director of Community Relations. And on behalf of President Lori Patton, I want to welcome all of you to Middlebury College. It is a privilege and an honor to host the Vermont Supreme Court today as they hear oral arguments in 4 cases. As many of you know, the justices usually hold term in Montpelier, but we are very fortunate to have a state Supreme Court that is so willing and open to bringing the court to the community. As President Patton has noted, this offers a rare opportunity for our students and community members to learn more about Vermont's judicial system by experiencing the appellate process in person. I want to thank Chief Justice Paul Reiber, Justice Beth Robinson, Justice Harold Eaton, Justice Karen Carroll, Justice William Cohen, and retired Justices John Dooley and Marilyn Skoglin, who are here with us today teaching a J-term course, and we're so very grateful to both of you for bringing your knowledge and expertise to our students. Justices Dooley and Skoglin are here today teaching a J-term course focused on the workings of state Supreme Courts. I also want to thank all of Middlebury College facilities, dining, and media services staff, as well as the Sheriff's Office and court personnel for all of their collective hard work to make these court proceedings today run smoothly. Finally, for safety and security reasons, in the event of an emergency or building alarm, please proceed immediately to the nearest exit. Exits are located on both sides of the room and in the back of the room. Thank you very much.
Do you want to come up and see if you can? If there's, do you have a stand? Yeah, that would be better. Oh, no, no. I know, now that I'm closer to it, but it looks like
Excellent. So Heather, I'll give you that.
and then when do you,
Yeah, I mean, does it have to be that close? Can it, I mean, can it be back a little bit? That would be my preference. Me too.
Is this working on now? Is it on? So I should go.
The Honorable, the Supreme Court.
Thank you very much. Please be seated.
Good morning, Your Honors. The matter before the court this morning is the case entitled T.C. versus L.D., docket number 2019-229. Representing the appellant, T.C., is Laura Byerly. Seated at counsel table with Ms. Byerly is McGuire Curran. Representing the appellee, L.D., is Samantha Lednicki.
Thank you very much. Before we start, let me thank Middlebury College, the students that are here for coming to witness this event. These are live hearings. We're very pleased to be here. I want to thank our staff and the excellent security that we've got. So many good people are helping us out with this process here this morning. So after that, let's get started, counsel.
Good morning, Your Honors.
Good morning.
My name is Laura Byerly. I'm from Vermont Legal Aid, and I represent the appellant in this case, T.C. I'm asking the court to remand this case and allow a victim of sexual assault to seek the basic protections afforded all other victims of sexual assault in Vermont. The right to be left alone by the person who assaulted her. TC is a teenage girl. She isn't able to be here today because she has midterm exams. She has never been allowed her day in court. She's bravely willing to discuss in a public courtroom the intimate details of one of the most traumatic days of her life, just in order to get a protection order. She simply wants to be left alone. She doesn't want the person who assaulted her coming into her classroom or her work while she's there. She doesn't want to be forced to come in contact with him at school or social events. She wants to be free of the trauma that repeated exposure to the person who assaulted her causes. A protection available to all other victims of sexual assault, but denied her simply because the person she accuses is a teenage boy.
So could you just explain to me as best you can the procedure? She filed for a civil stalking order in the Superior Court Civil Division.
Yes.
It was denied ex parte, correct?
Yes.
And then she has a statutory right to a hearing, which she requested.
That's correct, Your Honor.
And then at that hearing, then Judge Torr requested briefing regarding the ability to have a minor defendant, correct?
Right. Yes, Your Honor. Judge Torr requested briefing. We supplied briefing prior to giving any argument on the merits of this case.
And then she issued her written decision on that.
Yes, Your Honor. I'm sorry, I'm having a
I'm
hard time hearing.
I'm not sure if I'm dialed in or not, but okay, thank you.
It will take TC years to recover from the trauma and harm caused by the sexual assault. From the courts, she is only seeking a protection order and understands it is her burden to prove her case. She is only asking for the opportunity to do so.
So can you talk a little bit that the trial court was concerned about if we construe the stalking statute to apply to minors as well as to adults, the trial court was concerned about the logistical challenges that would present because minors typically require a guardian ad litem or a next friend or someone else to help protect their interests in court. How would that work in this docket where that's not a regular process that the court's prepared to accommodate?
Respectfully, the court should be prepared to accommodate. It is an obligation that the court has under Rule 17 when a minor or an incompetent person is sued or is seeking suit. The court is required to either appoint a guardian ad litem or make any order necessary to protect a minor or an incompetent person, and that includes appointment of guardian ad litem, appointment of counsel, if that is necessary. So the court is required under Rule 17 to make that inquiry and decide what protections are necessary in order to protect the minor, but that is not a bar to having the case heard. That is simply a procedure that needs to be followed if the court feels that additional protections are necessary for a minor. The court may do an inquiry and decide that competent counsel is sufficient, or they may order any other order that the court deems necessary. But there already is that requirement in any civil matter when a minor is a party to the case.
So are you talking about minors as defendants as well?
Yes, the Rule 17 refers to both minors who are plaintiffs and minors who are defendants.
What about the statute?
The statute is silent. The statute is meant to protect persons who are victims of sexual assault or stalking. And TC is a person and a minor, as is LD. And as persons, they should be protected under this statute. Vermont's protection order statutes have had a history of being ever more expansive. They started out as only protecting spouses in divorce situations, and have grown over many amendments to first include spouses and persons living as spouses, as well as people over the age of 60, and then who are living in the same dwelling, and then it expanded further in the relief from abuse statute to include household members. And then in 2005, the legislature deemed fit to expand the protection for sexual assault survivors to all persons. The appellee and the trial court want to limit minors, the application of protection orders against minors to those available in the relief from abuse statute, because in the relief from abuse statute, it does specifically mention minors when discussing dating relationships as a household member. I argue that that provision in that statute, in 15 VSA 1101, defining household members, is an expansion, and it provides clarity, because we would not ordinarily think of a dating relationship as necessarily being a household member. So the legislature included that phrase to include dating relationships in a household member, which wouldn't necessarily be a logical conclusion.
But those are in family court orders. Those are in the family court orders, not in the civil division order.
That's correct.
And the civil division order, under the civil stalking and sexual assault, there is no provision such as the household member. Is that important to you?
It's important only in that the two statutes are part of one common scheme, and that scheme is meant to protect all persons. If you are a family and household member, you can seek protection in the family division. If you are not a family or household member with the other party, then you seek protection for stalking and sexual assault in the civil division, and that is the only reason for the difference. If we read the household member definition as providing an exclusionary list, so that only minors who are dating, so that it only applies to minors who are dating, well, that entire phrase is minors or adults who are dating. So therefore, we would have to exclude minors and adults, which is an absurd result.
It's an interesting wording, though, and now I'm talking about the RFA statute, not the stalking statute, but because they relate, we're looking to the language. It was interesting that minors and adults only appear sort of grammatically to modify those who are dating or who have dated, suggesting that the rest of the definition of household members isn't so expansive as to include minors and adults.
I would read that as a clarification of why we would include people who are dating in household members, and not a limitation on household members. Household members is normally given its plain meaning. It can mean people who share a dwelling, and they are not required to be related by blood or marriage. They're not required to be family members. And it's the same definition that's used in the criminal domestic assault provisions to include that large family of who you would normally think is a household member, as well as the people that the household members may be dating and involved in an intimate relationship, to provide protection for intimate partner violence.
We usually only get into this discussion about other statutes and legislative intent if we find that the statute at issue is ambiguous. You spent a lot of time in your brief talking about legislative intent and comparing it to the RFA statute. Do you feel the stalking statute is ambiguous?
I don't feel the stalking statute is ambiguous. The stalking statute is meant to protect all persons, and the focus of a protection order statute should be on the person it's meant to protect. And TC is a person. Minors are persons. Minors are persons under many other statutes. There's no limitation in the stalking order statute or in the relief from abuse statute or in any of the protection order schemes to minors or adults. When the legislature saw fit to carve out a protection order statute for adults, they did so specifically in the vulnerable adult statute. But there is no such limitation in the orders against stalking and sexual assault or in the relief from abuse statute. So those protections should be available to all persons who are victims of sexual assault, such as TC.
You see, Council, just let me interrupt. You see, we've got cards for the time. I hope both sides are aware of this. So,
Thank you.
yep.
One of the things that the appellee has often brought up is that there are supposedly to be other remedies available for TC, and that she should be able to be protected or provided with assistance through the criminal process or through some other process through school.
Wouldn't that be true with an adult as well? If that's the argument, then adults shouldn't be able to bring them either.
That's correct. The restraining order statutes, the protection order statutes, are specifically available to survivors and victims of sexual assault in addition to any remedies. It's very clear in the statute. And frankly, TC has not received any other remedies. She doesn't have a voice in any kind of criminal proceeding because the criminal proceedings would be in the juvenile court, and they would be confidential proceedings, and she did not even receive any notice or any information about those proceedings until after they had concluded. So and there's very little notice that a victim is allowed. There's almost no voice that a victim is allowed within the criminal proceedings. So this is her opportunity, just as it is for any other sexual assault survivor, to obtain protection, to obtain a simple civil order that says, leave me alone.
Can you talk a little bit about the confidentiality concern for similar types of proceedings involving juveniles? We make that confidential. It's confidential by statute, actually. Is there a concern that construing the statute to apply to minors potentially undermines the policies of protecting their confidentiality in this non-private proceeding?
Well, there are two things that I would say in response to that. First of all, TC is willing to waive her confidentiality and state in a public place very private, very intimate details in order to obtain protection from the courts, and she has been denied that right. And also, the protection that's